Hey YouTube family and GN subs, Humberto from GrayLaw TV here at you with some GN. So what I do, that's what I do. I give you good news. We talk about complicated subject matters. I break it down. I make it very, very simple. That's what we do. And real cases. I have two today that are really interesting. I want to give you some really important information regarding these two cases. So, hey, let's get at it. A lot to talk about today. RFEs, NOIDs, Notice of Intent to Revoke. So these are usually notices that come prior to immigration having the ability to deny your case. So they're really important. You can provide additional information when they request this evidence from you, or a notice of intent to deny. Usually that's in connection with a family case. So they give you an opportunity to respond to the issues that are present in the case, and normally you're able to respond. Now, there was a memo in 2013, and this memo said basically that immigration officers are instructed to issue the notice of intent to deny, or the RFE, or the notice of intent to revoke prior to denying the case. That was the memo, that was the policy. So that meant, immigrants had a chance to respond before their cases were denied. Well, in 2018, the Trump administration said no, officers in their discretion can deny a case for simple mistakes. They can deny a case without issuing an RFE or a NOID or notice of intent to revoke. What we were seeing a lot of denials. It was horrible. It's like, wait a minute. I'll give you a perfect example. I had one case where we filed an adjustment. It was a marriage case, and all of a sudden I received a denial, and usually that never happens. Usually the case goes to the district office. The district office at the interview, if there's any simple mistake, etc., they get asked for that information. You would provide it and the case would be approved. In this case, I received a denial. I was like, this is crazy. I've never, had this before. And the reason they stated was that the social security number of the petitioner was not present in the application, when in fact the actual taxes were provided to them. In any event, we got it resolved. We had to do a motion to reopen, get the case back reopened. It was ultimately approved. But again, here's the good news, folks. That policy is gone. They can no longer deny cases outright. So if there's a simple mistake, or if there's an opportunity, if they can issue an RFE or a NOID that would result in the case being approved, they're going to do it, right? So they're going to issue back on the table. That old policy gone of just straight denials, no longer in play. That's great news. Another bit of good news, the Diversity 2021. So what's been happening is, as you know, there's 55,000 visas available annually in the diversity lottery. And you have to act quickly if you're going to get that visa, because in September of the fiscal year, if you don't have your green card by then, under this diversity lottery, the numbers run out and you lose a lifetime opportunity of getting the green card. So this year for the 2021, there are 24,000 visa lucky lottery winners that sued in federal district court. And they said, look, you need to adjudicate these visas so we can get our once-in-a-lifetime green card. And in that lawsuit, they instructed immigration to approve the green card prior to September of 2021 for the 2021 Visa Diversity Lottery. It's really interesting. I'd love to see what's going to happen with that case. It's injunctive relief, so it means that they have to act fast. And as I spoke before, there are the previous lottery winners because of, COVID, 2020, 2019, that were also affected. Visas not issued. So this case will be a good starting point to see what's going to happen with those old diversity cases. Hey, they may be back in play, may be able to get that green card. Hey, that's what we do as immigration attorneys. We sue the government. We make sure that they do what they're supposed to do. Here's another bit of good news in the EB-5 space. EB-5, if you invest $1 million, or in a target area or regional center, $500,000, basically you get a green card. You have to show, that you create 10 jobs over a 2-year period. So the Trump administration wanted to tighten the rules regarding the EB-5 program, and they increased the threshold investment amount from $1 million to $1.8 million, from $500,000 in a target area or a regional center area to $900,000. So a target area is an area where there's high unemployment, right? It's based on a location. So the investment amount is dropped to the $500,000. A regional center is an entity that made an application to the government to make the threshold amount lower to $500,000. Why? Because this regional center proves by an econometric standard that the area in which they're creating jobs is an area of high unemployment, and the creation of the jobs is going to help the community and the economy, etc. So the investment amount is lower. Well, the good news, these immigration attorneys again sued federal district court, and the judge just found that the acting director of DHS was improperly appointed, struck down. The higher amount no longer applies, reinstituted the lower threshold capital investment. This is great for a lot of regional centers. I myself, with partners, have a regional center up in Fresno, and you have a hard time raising capital at the higher threshold amount. I mean, 1.8 million and 900,000. It's a lot of money for a lot of people. So this lower threshold amount, I think it's going to be good. It's good for the overall economy, right? This is all about creating jobs. So back in play, great news. Happy to hear that. As I do, talk about real-time cases, right? I got two for you today. Really, really cool. We always talk about the extension of the work permit, right? So this one, 60 days. Remember, I always tell you, include the barcode that comes with your approval of the work permit with your extension. That helps to expedite the issuance of the work permit. Also remember, they're going to be issuing EADs. These are work permits, EADs, 2 years instead of 1 year. That is fantastic news. I'm so happy about that. So this next case demonstrates that once you file for the extension of your work permit, when you get the receipt, let's look at this receipt. Your work permit is automatically extended for 180 days from the expiration date of the card. That's very important for I-9 purposes. You have a job, right? Your employer says, look, your work permit's expired. You need to extend it. Well, what you can do is you give them the receipt and say, look, my EAD is automatically extended for 180 days. Now, there is a proviso. Let's look at the proviso. The automatic 180 days only applies to those EADs in certain categories. They list a link here of USCIS.gov/I-765, which is garbage. It doesn't tell you the code. It's so frustrating, right? I had one of my clients gave me a call, wanted some I-9 advice on an employee that they were going to hire, wanted to know whether or not this EAD was automatically extended. I go to that website, I couldn't find the code, right? I had to dig. I went to USCIS.gov, I-9. There I found some of the codes, okay? But make sure that you check your code. The code on the actual receipt matches the code that you're requesting on your EAD card. Make sure the code is included in that 180-day extension period. Hey, YouTube family, thanks so much. We're reaching 4 million views. Help us out. Help us out. 4 million views, 50,000 subs. We're getting there, folks, and you are the reason. I really appreciate your support. I appreciate all the help. Give me thumbs up, like, and subscribe. We'll talk to you soon.